Good day everyone, we are Group 6 and we are here to present the Article 8 of 1987 Constitution of the Philippines, which is the Judicial Department. So before we discuss the provisions in this article, I would like first to discuss what are the two courts in judiciary branch. So first court is yung Supreme Court. Yung Supreme Court is siya yung pinakamataas na court dito sa Pilipinas. And binubuo siya ng isang Chief Justice and 14 Associate Justices. Then, meron din mga power yung Supreme Court but it will be discussed in Section 5 later on. So, under ng Supreme Court, makikita nyo yung mga different kind of courts and ayan yung mga tinatawag na lower courts. The first three courts are Court of Appeals, Sandigan Bayan, and Court of Tax Appeals. Yung Court of Appeals is the primary appellate court of the Philippines. It is exercising its powers, functions, and duties through 23 divisions. Then, yung 23 divisions, it is divided in 3 locations, which are the City of Manila, Cebu, and Cagayan de Oro. 17 stations are located in City of Manila, while the 18th, 19th, and 20th divisions are located in Cebu City. And the 21st, 22nd, and 23rd divisions are located in Cagayan de Oro City. Then, yung Court of Appeals is naka-assign din siya na mag-review ng mga cases. Then, after niya i-review yung cases, ipapasa niya na yun sa regional trial courts as well as sa mga quasi-judicial agencies such as Civil Service Commission, Securities and Exchange Commission, National Labor Relations Commissions, and the Land Registration Authority. And yung Court of Appeals is nagre-review din siya ng mga cases na yung sentence is reclusion perpetua or life imprisonment. Then next is yung Sandigan Bayan. Yung Sandigan Bayan naman is isa siyang anti-graft court na mayroong jurisdiction to try public officers with a salary grade of 27. And also, yung mga public officers na merong criminal cases involving violation of the country's laws on graft and corruption. Next is the Court of Tax Appeals. It has exclusive jurisdiction to review and appeal decisions in cases involving disputed assessments, refunds of internal revenue taxes, fees or other charges, penalties in relation or other matters arising under the National Internal Revenue. Then, dito naman sa Court of Tax Appeals, any criminal offense or any criminal cases na involve yung tax is siya yung nag-handle. Then, as you can see guys, merong under ng Court of Appeals which are the Regional Trial Courts and the Sharia District Courts. Under ng Regional Trial Courts is Metropolitan Trial Courts, Municipal Trial Courts and Cities, Municipal Trial Courts, and Municipal Circuit Trial Courts. Then, sa Sharia District Court, merong isang under which is the Sharia Circuit Courts. So, next is the Section 1 of Article 8. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Then, sa provision na to, sinasabi na yung judicial power is vested lang siya sa isang Supreme Courts and also sa lower courts kung i-state siya sa law. What do we mean by judicial power? It refers to the power of the judicial branch of the government to hear cases and interpret, enforce, or nullify laws and statutes in order to render verdicts. It is vested in one Supreme Court. Judicial power is the power of the Court of Justice to hear and decide cases between parties who have the rights to sue in the court of law. Judicial power is only vested in one Supreme Court. It means that judicial power is assigned or it is secure in the possession of one Supreme Court. Then sa judicial power, included na din dun na yung Court of Justice is may responsibilities sila na magsettle ng actual controversies which includes rights which are legally demandable and enforceable. It is also to determine if there are happening like grave abuse of discretion which result to lack or excess of jurisdiction in the part of the government. The privilege against disclosure of information or communications that form the process of judicial decision. Then dito naman po sa deliberative process of privilege, sinasabi dito na yung process ng judicial decision is confidential siya. Judicial review, the power of the Supreme Court to determine the constitutionality of a law, treaty, ordinance, presidential issuance, and other governmental act. In judicial review, it is the power of the courts, specifically the Supreme Court. They have the power to analyze, review, or interpret the Constitution, and they also have the power what kind of legislative is valid to that certain controversies. This authority will be discussed in Section 5, Part 2. There are also three functions of judicial review, which are the checking, legitimizing, and symbolic. Checking, it is invalidating a law or executive act that is found to be contrary to the Constitution. Legitimizing, it is upholding the validity of the law that results from a mere dismissal of a case challenging the validity of the law. Symbolic, to educate the bench and bar as to the controlling principles and concepts on matters of grave public importance for the guidance of and restraint upon the future. Judicial inquiry, the power of the court to inquire into the exercise of discretionary powers to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction. So, pag sinabi natin judicial inquiry, isa siyang formal investigation na kinoconduct para sa public matter, and it is led by judges appointed by the government. Next is the Section 2 of Article 8. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts, but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5. So, sa section na to, sinasabi na yung Congress, merong silang power na mag-interpret, authorize, divide, and allocate the jurisdiction, meaning they have the power to make legal decisions and judgments. Pero dapat hindi ma-deprive ng Congress yung jurisdiction na meron yung Supreme Court over in the cases that will be explained in Section 5. Next is the constitutional safeguards to ensure the independence of the judiciary. First is Supreme Court is constitutional body that cannot be abolished by law. Supreme Court is established by Constitution, that's why it is called a constitutional body. Then, kahit anong law yung i-present is wala pa rin makakatanggal sa Supreme Court since isa nga siyang constitutional body. 2. Members of the judiciary are removable only through impeachment. So, pag sinabi nating impeachment, ito yung pag isa sa member ng judiciary is nag-commit siya ng crime na nagva-violate ng any law. Then, yung member ng judiciary na yun na nag-commit ng crime is pwede siyang matanggal. Of course, bago siya matanggal, pinagwawotohan muna ng mga House of Representative kung sino-sino yung mga favor na matanggal yung member na yun. If 1/3 ng House of Representative is bumoto na matanggal yung certain person na yun, then matatanggal siya through impeachment. 3. Supreme Court may not deprive of minimum and appellate jurisdiction. So, pag sinabi nating appellate jurisdiction, ito yung right ng court to change the decisions of a lower court. Then, may power silang mag-review, amend, and overrule decisions of a trial court or other lower tribunal. 4. Supreme Court has administrative supervision over all inferior courts and personnel. 5. Supreme Court has exclusive power to discipline judges and justices of inferior court. Yung Supreme Court, meron silang right na mag-discipline sa mga assigned people, sa judges and justices of inferior. 6. Members of judiciary enjoy security of tenure. Yung members of judiciary, they have a constitutional and legal guarantee that they cannot be removed to their position except when they did something wrong. 7. Members of judiciary may not be designated to any agency performing quasi-judicial administrative functions. When the person is already a member of judiciary, that person is not allowed to be designated in other agency that is performing quasi-judicial function. 8. Salaries of judges may not be reduced judiciary enjoys fiscal autonomy. Sinasabi dito na yung salary ng judges is fixed siya, then yung fiscal autonomy naman will be discussed in section 9. Supreme Court alone may initiate rules of court. 10. Supreme Court alone may order temporary detail of judges. 11. Supreme Court can appoint all officials and employees of the judiciary. Then, yung sa 9 and 10, sinasabi lang dito na yung Supreme Court is meron silang power na mag-initiate ng rules of court and mag-order ng temporary removal of judges kahit Supreme Court alone lang yung hihingi ng order na yun. And sa 11, they also have the power to choose who will be the member of judiciary. They can choose who will be assigned on that certain position. Then, ang purpose nito is to ensure that judicial proceedings are conducted fairly and that the rights of the parties are respected. Section 3 of Article 8, the judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year and after approval shall be automatically and regularly released. Fiscal autonomy is a guarantee given by the Constitution to certain units of the government. It is intended as a guarantee of separation of powers and of independence from political agencies. The appropriations for the judiciary cannot be reduced or deducted by the legislature that is lower than the past year. Section 4 of Article 8, the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. In Part 1, it is being stated that the Supreme Court must have the following members, which are the Chief of Justice and 14 Associate Justices. Any vacant position must be filled within 90 days starting from the date that the position is already vacant. Part 2, any kind of cases must be heard by en banc, and all other cases including the rules of court must also be heard by en banc. Members who join the deliberation must. Part 3, any cases that is being heard by division must be solved or decided by the members who took part on the issue or members who joined the deliberation. If the target quota of the vote did not reach it, then the case must be decided en banc. So these are the cases that must be heard en banc. When the Supreme Court sits en banc, the cases that will be heard will be decided by the majority of the members who took part on the deliberations and will vote thereon. 1. All cases involving the constitutionality of a treaty, international or executive agreement or law. As said in Section 4, Part 1, any case that involves constitutionality of treaty, international or executive, must be heard. Number 2, all cases which under the rules of court may be required to be heard en banc. Also, all the cases that falls under the rules of courts must be discussed or heard. 3. All cases involving the constitutionality, application, or operation of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations. 4. Cases heard by a division when the required majority in the division is not obtained. 5. Cases where the Supreme Court modifies or reverses a doctrine or principle of law previously laid down either en banc or in division. 6. Administrative cases involving the discipline or dismissal of judges of lower courts. 7. Election contest for president or vice president.
Division cases, yung ibang kaso daw o usapin ay makikita o maririnig sa division o en banc as the rules of court may provided. Dito daw yung mga kaso o usapin na maaaring marinig by a division at maaari daw tong mapagdesisyonan o ma-resolve sa pamamagitan ng pagsang-ayon ng nakararami sa member na kung saan naging parte upang mapag-usapan ng issue at makapagdesisyon na bumoto para ma-resolve ang issue. Ang kinakailangan daw na boto ay at least 3 votes, tapos kung ang boto daw ay hindi umabot sa 3, yung case daw shall be decided en banc. Makikita to sa Article 8, Section 4, Part 3. Section 5, the Supreme Court shall have the following powers. First, exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions of certiorari, prohibition, mandamus, quo warranto, and habeas corpus. But first, ano nga ba yung certiorari? Certiorari usually ginagawa to kapag may nag-appeal, example is Regional Trial Court, hindi pa rin kontento yung nagreklamo, so nag-appeal siya, umakyat na to sa Supreme Court. Si Supreme Court naman, pwede siya mag-request ng records ng kaso at dalhin itong records na to papunta sa Supreme Court. Next is prohibitions. Ito naman isang kasulatan na kung saan inuutusan ang lower court ng superior court na tanggalin na yung mga further proceedings in action or matter. Third, yung mandamus. Isa itong pag-uutos na nakalagay sa isang papel na inuutusan ng higher court yung mga lower court na gawin ng isang gawain. Example is may binaba si Regional Trial Court sa isang grupo. Ito ay gagawin para sa proseso na pag-iimbestiga para i-perform ang isang duty. Next is yung quo warranto. Ito naman yung kapag ang isang grupo ng tao o corporation ay nagkaroon ng mga gawain na labag sa batas ng Pilipinas, may karapatang mag-release ang Supreme Court ng quo warranto. Ito ay ginagawa para paalisin sa posisyon or kunin ang prangkisa para hindi na makapag-cooperate o operate. Ang habeas corpus naman, it means that you have the body. It is a Latin word which means you have the body. Second is review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the rules of court may provide final judgment and orders of lower courts in. So, this Article 8, Section 5, Part 1 and 2, dito dinidescribe ang judicial powers, which is the specific power of the Supreme Court kung saan the power to settle actual controversies involving rights which are legally demandable and enforceable. In short, ito yung power ng korte para mag-decide ng mga actual cases, actual controversies involving yung mga rights nating mga tao, which is right natin as a human, being against the state or against other people's scope of judicial power. Specifically, tinatawag naman to na adjudicatory power to settle actual controversies involving rights. And next is judicial review, which is power of the Supreme Court din. It interpret and make judgments with respect to the law. And last is incidental power, meaning powers essential for the discharge of their judiciary function. Ito yung mga particular idea na ginagawa daw ng Supreme Court. Assign temporarily judges of lower courts to other stations as public interest may require. Sinasabi po dito na mag-assign ng temporary judge of lower courts sa ibang himpilan na maaaring kailanganin ng iba o as public interest. Ang pansamantalang pagtatalaga ay hindi dapat lumagpas ng 6 na buwan nang walang pangsang-ayon ng judge. Order a change of venue or place of trial to avoid a miscarriage of justice. Iatas ang pagbabago ng venue o lugar ng paglilitis upang maiwasan ang miscarriage of justice. And pang-5, promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. Magbigay daw o maglagda ng rules patungkol sa pangangalaga at pagpapatupad ng mga karapatang konstitusyonal, pleading, practice at pamamaraan sa lahat ng mga korte. Ang pagpasok sa practice of law, the integrated bar at legal na pagtulong sa mga tao na underprivileged o walang kakayahang kumuha ng abogado, ang mga patakaran daw na yun ay dapat simple at hindi magastos na pamamaraan for the speedy disposition of cases. Dapat din daw na maayos o organize sa lahat ng korte na magkakapareho ng level or same grade. And yung pang-6 naman, appoint all officials and employees of the judiciary in accordance with the civil service law. Appoint daw lahat ng officials and employees ng judiciary ayon sa civil service law. Powers of the Supreme Court. First, exercise original jurisdiction. Second, exercise appellate jurisdiction. Third, electoral tribunal for presidential and vice presidential contest, sitting ambang over all contest relating to the election, returns and qualification of the president or vice president. Compositions of the Supreme Court. A. Chief Justice. B. 14 Associate Justices. Ang Supreme Court ay binubuo ng 15 members, 1 Chief Justice, and 14 Associate Justices pursuant to Article 8 of 1987 Constitution of the Philippines. The court is composed of the Chief Justice and of the 14 Associate Justices, all of whom are appointed by the President from all the list of nominees made by the Judicial and Bar Council. Katulad nga nung sa Section 8, ang JBC is a significant organization when it comes to judiciary kasi nga sila yung namimili at sumasala sa mga applicant na gusto mapunta sa specific na position. Next is rule-making power of the Supreme Court. The Supreme Court declared that the 1987 Constitution took away the power of Congress to repeal, alter, or supplement rules. Supreme Court ay may exclusive power upang maglabas ng patakaran patungkol sa pangangalaga at karapatang konstitusyonal na makikita sa Section 5 Part 1. Ang rules ng pamamaraan ng special courts at ang quasi-judicial bodies ay mananatiling effective maliban kung hindi inaprubahan ng korte. Next naman po ay ang power of appointment of Supreme Court. The Supreme Court was also given the power to appoint all officials and employees of the judiciary. O sinasabi po dito na ang Supreme Court ay may kapangyarihan din na mag-appoint ng mga official na tao o employee of judiciary. At maaari lang silang ma-appoint kung sila ay pasok sa qualifications ng judiciary.
As said earlier, yung Supreme Court is composed of 1 Chief Justice, then yung current Chief Justice ng Supreme Court ngayon ay si Alexander G. Guzmondo, then na-assign siya last April 5, 2021. Then he replaced Justado Peralta who retired early on March 27, 2021. Then, nag-serve din siya dati as an Associate Justice ng Supreme Court from 2017 to 2021. Ang nag-assign sa kanya to be the Chief Justice of the Supreme Court is the President of the Philippines, Rodrigo Duterte, and the person who preceded him is Jose C. Mendoza. Supreme Court is also composed of 14 Associate Justices. As you can see, sila yung 14 Associate Justices ng Supreme Court and they are arranged according to kung gano'n na sila katagal nagsiserve sa Supreme Court. First is Estela Marcelino Perlas Bernabe. She was assigned on September 16, 2011 up to now. Next is Marvic Mario Victor Famorca Leonen. He was assigned since November 11, 2012 up to now. Next is Alfredo Benjamin Sabiter Kagiwa. He was assigned since January 22, 2016. Next is Ramon Paul Layugan Hernando. He was assigned since August 2017, 2018. Next is Rosemary De Claro Carandang. He was assigned since November 26, 2018. Next is si Ami Lazaro Javier. She was assigned since March 6, 2020. Next is Henry Jean Paul Balinghasay Inting. He was assigned since May 2017, 2019. Next is Rudel Baquillar Zalameda. He was assigned since December 5, 2019. Next is Mario Villamor Lopez. He was assigned since December 5, 2019. Next is Edgardo Lau de los Santos. He was assigned since December 5, 2019. Next is Samuel Hofano Guerlan. He was assigned since January 8, 2020. Next is Ricardo de Rivera Rosario. He was assigned since October 8, 2020. Last is the most recent assigned, Joseph Elarde Lopez. He was assigned since January 26, 2021. So, kung mapapansin nyo guys, 13 Associate Justices lang yung naka-indicate dito sa amin. Kasi meron pang isang vacant position since kaka-assign lang sa bagong Chief of Justice nga noong April 5, 2021. Kaya meron pang vacant position for Associate Justice.
Temporary assignments of judges of lower courts to other stations as public interest may require and not to exceed 6 months without the consent of the judge concerned. Section 6. The Supreme Court shall have the administrative supervision over all courts and the personnel thereof. So, ang Supreme Court daw ay dapat magkaroon ng pangangasiwa sa lahat ng mga courts at sa mga tauhan nito. Dito papasok yung power of administrative supervision over all courts and the personnel thereof. Under Bar Matter number 209, administrative cases which are not to be heard by ENCBAC includes only A. Administrative judges, B. Disbarment of lawyers, C. Suspension of more than 1 year, and D. Fine exceeding 10,000. So let's now proceed on Section 7. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is a natural-born citizen of the Philippines. Second, the Congress shall prescribe the qualifications of judges of lower courts, but no person may be appointed judge thereof unless he is a citizen of the Philippines. Third, a member of the judiciary must be a person of proven competence, integrity, probity, and independence. So, minimum of age of Supreme Court judges and eligibility for Supreme Court judges. Part 1, hindi dapat may talaga na member of the Supreme Court o any lower collegiate court ang isang tao, maliban kung siya ay natural-born citizen of the Philippines. Ang member of the Supreme Court ay kinakailangan na 40 years old at kinakailangan na sa loob ng 15 years o higit pa ay naging judge na ng isang lower court or nag-practice bilang abogado ng Pilipinas. Ito naman po papasok ang qualifications. A. Chief Justice and Associate Justices of the Supreme Court. Ang una ay natural-born citizen dapat. Pangalawa, at least 40 years old. Pangatlo, 15 years or more as a judge of a lower court or has been engaged in the practice if law on the Philippines for the same period. And last is, a person of proven competence, integrity, probity, and independence. Part 2, dapat naman daw magpatupad o maglagay ng qualification ng isang judges of lower courts ang Congress. Ngunit walang sino man ang maaaring ma-appoint bilang judge nito, maliban kung siya ay isang citizen of the Philippines at member ng Philippine Bar. Last ay yung pangatlo, ang member naman daw ng judiciary ay dapat may napatunayan na may kakayahang integrity, probity, and independence. Kabuuan, ang Section 7, tumutukoy ito sa dapat na maging qualifications ng isang judge o chief of justices. Dinedescribe dito yung mga dapat taglay ng isang tao para ma-appoint siya bilang isang judge o chief of justice. Next is Section 8. Dito papasok yung Judicial and Bar Council composition na makikita sa Article 8, Section 8. So, ang una, ang JBC daw o Judicial and Bar Council is a significant organization when it comes to judiciary. Sila daw ang namimili at sumasala sa mga applicant na gusto maging judge o chief of justice, mapa-lower courts o Supreme Courts. Ang composition naman ng JBC, ito naman ay nagmula sa iba't ibang sector daw ng government. Yung mga tao daw sa JBC sila yung namimili at sumasala sa performance at qualifications ng mga taong gustong mag-apply sa position. Ang JBC ang pipili kung sino ang mga qualify for that position at kung sino ang magpo-proceed. Pagtapos doon, isasubmit nila yung mga list na na-approve nila sa President. And the President has the power to appoint katulad nung na-discuss sa Executive Department. The President has a power to appoint them into that position. Pwede siya maging judge o Chief of Justice, particularly sa Supreme Court. Ang President daw ang pumipili ng Chief of Justice ng ating bansa with the recommendation ng JBC. Second, dito papasok naman yung appointment regular members of the JBC shall be appointed by the President for a 4-year term with the consent of the Commission on Appointments Article 8, Section 8. Ang regular members of the Council ay hihirangin na regular members of JBC ng President sa loob ng 4 na taon na may pahintulot ng Commission on Appointment. Sa mga nauna naman na naging members ng Council, ang representative of the Integrated Bar naman ay maglilingkod o magsiserve ng 4 na taon. Ang Progressor of Law ay 3 years, the retired Justice of for 2 years at ang representative ng private sector ay maglilingkod ng 1 taon. Ang pangatlo, ang clerk of the Supreme Court naman daw ay dapat ang secretary ex officio ng council. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceedings. Pang-apat, the regular members of the council naman daw ay dapat makatanggap ng salary o profit na maaaring i-provide o i-assign ng Supreme Court. Ang Supreme Court naman daw ay dapat mag-provide ng annual budget nito ng paglalaan para sa council. Last, the council shall have the principal function of recommending appointees to the judiciary. Ang council naman ay dapat magkaroon ng recommending appointees to the judiciary. Ito daw ay maaaring gumanap o kumatawan sa iba pang gawain at tungkulin na maaaring i-assign sa kanila ng Supreme Court. Composition of Judicial and Bar Council. First, Chief Justice as ex officio chairman. Second, Secretary of Justice as an ex officio member. Third, Representative of Congress as an ex officio member. Fourth, Representative of the Integrated Bar. Fifth, a Professor of Law. Sixth, a retired member of the Supreme Court. Seventh, Private Sector Representative.
So, ito po yung mga composition ng Judicial and Bar Council sa Philippines. First is the Chief Justice of the Supreme Court and the Judicial and Bar Council ex officio chairperson, Alexander G. Gismondo. Alexander G. Gismondo is the current Chief Justice of the Supreme Court and also the Judicial and Bar Council ex officio chairperson. Honorable Menardo I. Guevara is the Secretary of Justice, Judicial and Bar Council ex officio member. Honorable Vicente S. E. Veloso III is the Congressman, Judicial and Bar ex officio member. Next is Honorable Franklin J. De Monteverde, Judicial and Bar Council regular member representing the Integrated Bar of the Philippines. Next is Honorable Noel G. Tiham, Judicial and Bar Council regular member representing the Academy. Next is Honorable Jose C. Mendoza, Judicial Bar and Council regular member representing the retired Supreme Court Justices and Executive Committee Chairperson. Next is Honorable Toribio E. Ilaw Jr., Judicial and Bar Council regular member representing the private sector.
Procedure for appointment. The President shall appoint regular members for a 4-year term with the consent of the Commission on Appointments. In Article 8, Section 8, Paragraph 2, state that the regular members of the Council shall be appointed by the President for a term of 4 years with the consent of the Commission on Appointment. Of the members first appointed, the representative of the Integrated Bar shall serve for 4 years, the Professor of Law for 3 years, the retired Justice for 2 years, and the representative of the private sector for 1 year. Sinasabi dito, provision na ang mga regular na member ng kapulungan or council ay tatalaga ng Pangulo sa loob ng 4 na taon na may kasamang pahintulot ng Commission on Appointment. Nakasaad din dito ng representative ng Integrated Bar ay dapat maglingkod sa loob ng 4 na taon. Ang Professor of Law maglilingkod naman sa loob ng 3 taon, ang retired Justice naman maglilingkod sa 2 taon, at ang huling representative of private sector kung saan maglilingkod naman ng 1 taon. Example dito ay ang mga representative na inappoint ng ating Pangulong Duterte na kasalukuyang nakaupo ngayon. Isa na dito si Judge Jose C. Mendoza, which is representative siya ng retired Justice or retired Supreme Court Justice. Next naman is si Judge Toribio E. Ilaw Jr., which is representative siya ng private sector. Next is Judge Franklin J. De Monteverde, which is representative siya ng Integrated Bar. And last is Judge Noel G. Tiham, which is representative siya ng Professor of Law. Judicial and Bar Council. It was principally designated to eliminate politics from the appointments of judge and justice. Thus, in Article 8, Section 8, Paragraph 5, The Council shall have the principal functions of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Ang pangunahing tungkulin ng Judicial and Bar Council ay magrekomenda ng mga ina-appoint sa judiciary at sa opisina ng ombudsman para sa examination o pagsusuri sa itatalaga na Chief Justice sa kataas-taasang hukuman o Supreme Court. Layunin nito na mapahusay ang kalidad ng paghahanap sa proseso ng pagpili, ganoon din sa proteksyon nito sa anumang impluwensya na maaaring makaapekto sa desisyon na paghalal ng Chief Justice. Ang pinakamalagang tungkulin at gawain ng Judicial and Bar Council ay ang paggawa ng listahan ng mga nominado para sa posisyon ng Chief Justice sa Supreme Court. Ang idea sa paggawa ng Judicial and Bar Council ay inintroduce ni former Chief Justice Roberto Concepcion noong debate ng 1986 Constitutional Commission para ma-depolitize ang proseso ng appointment. What do you mean by depolitize? Simply i-remove o alisin ang impluwensya ng politika sa pagpili ng Chief Justice na hindi dapat pabor sa anumang tao sa politika o ninuman sa pag-appoint ng Chief Justice. Ang JBC din ang responsible sa pag-handle at manage ng Philippine Bar Examination. They're the one who's possible that they can handle the upcoming lawyers and justice. Ang paghahanap ng kandidato para sa Chief Justice ay hindi basta-basta binibigay lamang sa konstitusyon dahil walang sino man ang karapat-dapat maliban kung siya o itong kandidato na itatalaga sa posisyon ng Chief Justice ay napatunayan na mataas ang kahulugan ng moralidad at probity o mataas na prinsipyo ng moralidad o katapatan sa kanyang tungkulin. Ang JBC ay magsisilbing patas sa pagtatalaga ng Chief Justice dahil wala silang pinapaboran lalong-lalo na sa politika o impluwensya ng politika sa pagpili ng Chief Justice sa Supreme Court o sa kataas-taasang hukuman. Article 8, Section 9, the members of the Supreme Court and judges of the lower court shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointment within 90 days from the submission of list. The JBC ay mayroong layunin na gumawa ng listahan ng mga nominado na itatalaga sa judiciary o hukuman nang hindi bababa o tataas ng at least sa 3 nominado. At ang Pangulo ay maaari lamang pumili mula sa listahan na ito na ginawa at sinubmit ng JBC sa kanya. Hindi maaaring pumili ang Pangulo ng mula sa listahan na isinumiti sa kanya ng JBC o Judicial and Bar Council. Bakit at least 3 lamang ang nasa listahan ng nominado? Bakit hindi pwedeng sobra sa 5 o bababa sa 2? Ang dahilan dito ay upang bigyan ng Pangulo ng sapat na kalayaan ng walang limitasyon o restriction sa pagproseso ng kanyang pagpili. Kung hindi naman nagustuhan ng Pangulo ang list na ibinigay sa kanya ng JBC, maaari siyang mag-request ng iba pang listahan na kung saan tingin niya makakapili siya ng maayos. Ang provision din ito ay malinaw na nagsasabi at tumutukoy lamang sa mga appointee o itatalaga ng kandidato para sa Supreme Court at hindi para sa mga kasalukuyan ng nakaupo na miyembro o sitting justice sa korte na dati nang naitalaga ng JBC. Bakit naman sinasabi sa provision na ito na such appointment need no confirmation? Simple dahil ang prohibition against sa midnight appointments ay di na-apply sa appointments ng Supreme Court. Sa pangdahilan dito ay ang JBC ay merong mataas na reputasyon sa pagdimbang ng mga kwalifikasyon ng kandidato at masusing proseso para masigurado na ang kandidato ay merong or proven na napatunayang subok na in terms of probity, integrity at competence at independent o hindi na-impluwensyan o nakokontrol ng ibang tao, especially doon sa mga political people kaya hindi na kailangan na kumpirmahin pa, especially ng politiko sa kapangyarihan ng Commission of Appointment. Article 8, Section 10. The salary of the Chief Justice and of the Associate Justice of the Supreme Court and judges of lower court shall be fixed by law during their continuance in office. Their salary shall not be decreased. Sa provision na ito, nagkaroon ng issue na kung saan ang mga petitioner sa lahat ng station ng Manila ay naghahangad na ipagbawal o naghahangad na gumawa man lang ng aksyon ng Commissioner of Internal Revenue at ang Financial Officer ng Supreme Court laban sa paggawa ng anumang deduksyon ng buwis mula sa kanilang sahod. Ang mga petitioner na ito ay ang mga hinihirang at kwalipikadong mga hukom na namumuno sa 52, 19, and 53 respectively branches ng Regional Trial Court or RTC at National Capital Judicial Region sa Station ng Manila. They submit that any tax withheld from their emoluments or compensation as judicial officers constitutes a decrease or diminution of their salaries, contrary to the provision of Article 8, Section 10. Pinipunto nila na di dapat binabawas ang kanilang tax mismo doon sa kanilang sweldo. O sa mas madaling salita, hindi dapat binabawasan ang kanilang sweldo ng tax o buwis. Na contrary naman sa provision ng Article 8, Section 10. The court dealt with this bilang tugon sa representasyon na ang korte ay direktang itigil ang pag-aalis ng mga buwis mula sa kanilang mga sweldo sa finance officer. Noong June 4, 1987, muli itong pinagtibay ng court and bank. Ang mga debate at interpellation or paggawa ng aksyon at opinion ay nagpapahayag tungkol sa provision ng konstitusyon hanggang inaprobahan sa wakas ng komisyon na ang tunay na layunin ng mga framers o mga tao na gumawa ng konsepto ng 1987 Constitution sa pag-adapt nito is to make the salaries of member of the judiciary is taxable. Ang average judge gross salary o sweldo ng ating judge dito sa Pilipinas ay nag-average ng 554,334 pesos o katumbas nito ng 267 pesos ng hourly rate. In addition naman, ang average bonus naman nila is nag-average ng 26,386 pesos. Estimated itong salary nila based doon sa salary survey data collected directly mula doon sa mga employees and anonymous employee dito sa Pilipinas. Isang entry-level judge na mayroong 1 to 3 years na experience sa pagtatrabaho o panunungkulan ay mayroong sweldo na nag-average ng 391,896 pesos. While on the other hand naman, isang senior level judge with 8 plus years of experience sa panunungkulan ng pagtatrabaho ay nag-average ang kanilang sweldo ng 693,923 pesos. Article 8, Section 11. The members of the Supreme Court and judges of lower court shall hold office during behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court and bank shall have the power to discipline judge of lower court or order their dismissal by a vote of a majority of the members who actually took part in the deliberation on the issues in the case and voted thereon. Manunungkulan ng isang miyembro ng Supreme Court at judges ng lower court hanggang sa edad na 70 years old o 70 taon. O kapag hindi na nila kayang gawin ang kanilang duty o trabaho. There is also disciplinary power in this provision, kung saan ginagamit ito ng Supreme Court and bank para sa mga judges sa lower court. Kung ang isang judges ng lower court ay may kinakaharap na issue na kaso, maaari silang i-remove o may alisin sa pwesto ng Supreme Court through disciplinary power at pagbotohin ito ng majority o karamihan. Ang decision ng Supreme Court regarding sa disciplinary power ay kailangan lamang kung may papataw or may impose ang dismissal of judge, disbarment of lawyer. Disbarment means no right to practice law or expel, and suspension for more than 1 year or fine exceeding of 10,000 pesos. Paano naman sa mga member ng Supreme Court ang mangyayari? Paano maalis ang membro ng Supreme Court? Maalis lamang sila through impeachment. It is stated sa provision ng Article 11, Section 2. The members of the Supreme Court are removable only by impeachment if they can be said to fail to satisfy the requirement of good behavior. Only if they are guilty of offense which are constitutional grounds of impeachment. The members of the Supreme Court may be removed from office on impeachment for conviction of bribery, culpable violation of the Constitution, treason, graft and corruption, other high crimes, and betrayal of public trust. Security of tenure is important and essential for independent judiciary para makasigurado tayo na hindi sila panig o in favor or mapanatili ang kayusan sa loob ng Supreme Court at judges ng lower courts. Since mayroong disciplinary power at impeachment na nangyayari para sa mga tiwaling miyembro ng Supreme Court, member at judges of lower court. Also, in Article 8, Section 2, tinutukoy doon kung gaano kahalaga ang seguridad sa paghawak ng office ng mga member ng Supreme Court at judges sa lower court. It states that no law should be passed reorganizing the judiciary when it undermines the security of tenure of its members. And undermines means pinahina. Kung mahina ang seguridad ng tenure sa bawat member, possible na walang batas na maipapasa. Tenure of the members of the Supreme Court and judges. Members of the Supreme Court and judges of lower court can hold office during good behavior until the age of 70 years old and they become incapacitated to discharge their duties. Nakasaad ito sa Article 8, Section 11 at nakasaad doon na the members of the Supreme Court and judges of lower court shall hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. Dito sa tenure na ito, sinasabi na maninilbihan lamang o manunungkulan lamang ang isang membro ng Supreme Court or judges ng lower court hanggang sa umabot sila ng edad na 70 taon o di na nila kayang gampanan pa ang kanilang tungkulin. Ang lower courts, ito yung mga RTC or MTC. Ito yung Regional Trial Court at Municipal Trial Courts. Article 8, Section 12. The members of the Supreme Court and of other court established by law shall not be designated to any agency performing quasi-judicial or administrative functions. Dito sa provision na ito, ipinapakita ang pagkakaroon ng sariling kapangyarihan ng Supreme Court at other court na ginawa ng batas at sa kapangyarihan ng agency na nagpe-perform ng quasi-judicial. Pinapakita ang pagkakaroon ng pagbukod ng kapangyarihan ng Supreme Court at iba pang court at ng quasi-judicial agency. Ano ba itong quasi-judicial agency na ito? Hindi sila korte pero may power sila na parang korte or this administrative agency that are not court of justice but empowered by law to hear and decide certain classes of case due to their specialized nature. Hindi sila korte but meron silang power magtinig ng mga case o kaso depende doon sa focus nila. Example dito is NLRC or National Labor Relations Commission ng DOLE. Nakafocus lamang sila pagdating sa mga labor case. Kung illegally inalis sa trabaho, pwede kang mag-file ng kaso sa NLRC. Hindi na kailangan sa RTC or sa MTC. Since nakafocus sila sa labor case. Sinasabi sa provision na ito na hindi dapat naka-officially assign or assign ng membro ng Supreme Court at iba pang court na ginawa ng batas dito sa quasi-judicial agency. Kung sa Supreme Court or other courts ka naka-assign, doon ka lang. Hindi ka dapat mangialam, manghimasok o gawin ang trabaho mo sa quasi-judicial agency na ito. Dahil may sarili silang power na ibinigay ng law para magdinig ng kaso na ayon lamang sa kanilang focus. Article 8, Section 13. The conclusion of the Supreme Court in any case submitted to it for decision en banc or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect signed by the Chief Justice shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any member who took no part or dissented or abstained from decision or resolution must state the reason thereof. The same requirement shall be observed by all lower collegiate courts. Ang purpose ng provision na ito ay siguraduhin ang implementasyon ng constitutional requirement kung saan ang desisyon ng Supreme Court at mga lower collegiate courts gaya ng Sandigan Bayan at Court of Tax Appeal ay may aabot after ng consultation ng mga member ng court sitting en banc or in division bago ang kaso i-assign sa bawat membro. Ang decision ay binibigay ng hukuman as a body or buo, not merely by a member. Its example is, ibibigay ito ng hukuman by group at hindi ng isang member lamang. Paano naman kung ang certification becomes absent since the regular performance of official duty is presumed or supposed to be true? Absence of certification not necessarily mean na ang kaso na isinumite para sa desisyon ay di na-reach o naabot bago ito ma-assign sa isang member para magsulat ng opinion doon para sa korte. Or simply, the absence of certification will not have the effect of invalidating decisions. Paano naman if the end of decision nagkaroon ng kakulangan sa certification? Magre-result ito sa failure na i-observe ang kinakailangang certification at mga basis ng omission sa court na iyon. At magsisilbi itong ebidensya. Article 8, Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused, due course, or denied without stating the legal basis. Therefore, walang desisyon ang ibibigay ng anumang hukuman nang walang malinaw na katotohanan o basihan. Sinasabi na ang court ay required na magpahayag ng factual at legal na basihan na kung saan nakabase doon ang desisyon. Ang anumang desisyon ng walang factual at legal basis ay mapapawalang bisa. The court explained that a resolution or not decision ang petition para i-review ang decision ng Court of Appeals is not a matter of right but of sound judicial discretion. Parang sinasabi dito na hindi ang kakayahan na magdesisyon ng Court of Appeals ay hindi about sa karapatan but more on kakayahan o freedom ng Court of Appeals na mag-decide. So kung ang petition ay ma-dismiss through resolution, there is no need to state the facts clearly and distinctly and the law on na kung saan ang decision ay nakabase. Because of the facts and law are already stated in the decision of the Court of Appeals. In Article 8, Section 15, Paragraph 1, nakasaad sa provision na ito na lahat ng kaso o bagay na naisampa sa ilalim ng epekto ng konstitusyon na ito ay kailangang mai-resolve o napagpasyahan na within 24 months mula sa petsa ng pagsusumite para sa Supreme Court. At unless na lang kung i-reduce ito o babawasan ito ng Supreme Court. Para naman sa lower collegiate courts, meron silang 12 months para i-resolbahin ng mga case o mapagpasyahan ito. At 3 months naman para dun sa mga lower courts. In Article 8, Section 15, Paragraph 2 naman, nakasaad naman na ang kaso o bagay na isusumite for decision or resolution ay mas sa ilalim ng memorandum ng korte which is required ng court itself. In Article 8, Section 15, Paragraph 3 naman, nakasaad dito na ang certification na kung saan nilagdaan ng Chief Justice or Presiding Judge ay kailangan na i-issue or i-attach without any hesitation doon sa record ng kaso o bagay and serve ito upon the parties. Na kung saan ang certification na ito ay nagsasaad ng rason na kung bakit ang desisyon o kaso o bagay ay hindi na isumite o na-submit within said period. In Article 8, Section 15, Paragraph 4, sa kabila ng pagtatapos ng nasabing mandatory period, ang korte ay magiging liable sa mga responsibility without any bias doon sa anumang resulta. It means the court must still decide a case or matter na applicable to doon sa maximum period provided without judge concern or any bias. So di nila tinotolerate anumang delay sa panahon na binibigay nila para sa kaso o bagay na isinampa na kailangan ng mapagpasyan o maresolba within the period na ibinigay nila. The period for decision making under Section 15, Article 8 does not apply to the Sandigan Bayan, only 3 months being a special court. The provision refers to regular courts of lower collegiate level that in the present hierarchy applies only to the Court of Appeals by 12 months. The provision ng Article 8, Section 15 refers only to the regular courts of lower collegiate courts, which is the Court of Appeals na sinasabi na mayroong 12 months para mag-decide ng mga case or kaso. While on other hand, sa Sandigan Bayan naman, on its special court is special court na same level din ng Court of Appeals and it's possessing all inherent powers na meron ang Court of Justice. Same function din ng trial courts. Sandigan Bayan, being special court, is of the power to promulgate its own rules regarding dun sa reglementary period ng mga undecided case under its jurisdiction. So, ang Sandigan Bayan, sinasabi na ang judgment doon sa mga pending case ay kailangan maisumite or mairesolba within 3 months, which is not applicable doon sa provision ng Article 8, Section 15. Well, ang Court of Appeals ay mayroong mandatory period ng 12 months para mapagdesisyonan o mapagpasya ng kaso, which is applicable doon sa provision ng Article 8, Section 15. Pinapakita sa provision na ito ang pagkakaiba ng Court of Appeals and Sandigan Bayan regarding doon sa mandatory period para magsumite ng case or kaso. Article 8, Section 16. The Supreme Court shall, within 30 days from the opening of each regular session of the Congress, submit to the President and the Congress an annual reports on the operation and activities of the judiciary. Ito, sa provision na ito, nakasaad, kailangan ng Supreme Court ay magsubmit ng annual reports within 30 days sa kada pagbubukas ng regular session ng Congress at isubmit ito doon sa President at sa Congress. Annual reports, example nito is yung operation and income or mga financial plans. So, ang purpose nito is to inform the Congress or Executive about dun sa mga financial needs ng judiciary. But as jurisprudence has said, jurisprudence means it's only regarding for law at wala nang iba pa. Maaari magsubmit Supreme Court sa Department of Budget and Management reports ng operation and income, current plantilla, personnel, plantilla, it means government approved list of position in any government institution, and work and financial plans, at iba pang reports regarding dito sa mga ito. So only lamang for recording purposes.